All right, future barristers, listen up. If you're gearing up for the Queensland bar exam, you already know that procedure isn't just important, it's everything. So today, we are going to laser focus on Division 33 of the Federal Court Rules. Let's get this stuff absolutely nailed down.
You've probably got the UCPR, the Uniform Civil Procedure Rules, down pat by now, right? I mean, you've spent countless hours on it. But here's the thing. The moment you step into federal jurisdiction, the whole game changes. And your success, not just in the exam, but out there in the real world, hinges on knowing exactly what those differences are. We're not just talking about a few new rule numbers, we're talking about a completely different strategic playbook.
So here's how we're going to break this down. We've got three main areas to cover. First, we'll look at managing the parties involved. Then, and this is a big one, we'll dive into how the court controls the courtroom itself. And finally, we'll tackle how evidence is handled the federal way. Ready? Let's get into it.
Okay, first up, managing the parties. So picture this. You're in court, and one of the parties just doesn't show up. Now, under UCPR Rule 476, the focus is really on what happens when the plaintiff is a no-show. But the federal court, it's a bit different. Federal Court Rule 30.21 gives the judge a whole toolkit of specific options, whether it's the applicant or the respondent who's gone missing. The court can adjourn, dismiss, or just go ahead with the hearing. It's way more detailed. So lock this one in your brain. FCR 30.21.
Okay, but what if it's even worse? What if nobody shows up? You know, just an empty courtroom. While the UCPR kind of deals with this under its general powers in Rule 477, the federal court gives us a specific, dedicated rule for this exact scenario. It's Rule 30.22, and it's crystal clear. The court can either adjourn the whole thing or just dismiss it. It's a subtle but important difference. Remember, FCR 30.22 is for when the room is empty.
Now, this is an interesting one. UCPR Rule 72 is all about what to do when a party dies during the proceedings, substituting them. But Federal Court Rule 30.24 tackles a really specific and, frankly, a bit of a nightmare scenario. What happens if a party dies after the hearing is all done, but before the judge has handed down the judgment? Well, Rule 30.24 is the hero here. It lets the court go ahead and deliver the judgment anyway. It's a crucial rule that stops a case from falling apart right at the finish line.
Okay, pay attention here because this is a rule with no direct equivalent in the UCPR. Let's say your client or a key party is in lawful custody. How do you get them to court? In the state system, you're probably thinking about subpoenas, but the federal court gives you a much more direct, more powerful tool, Rule 30.33. This rule lets you apply for a specific order to produce that person. It's a dedicated mechanism, a really important tool to have in your arsenal. Again, that's FCR 30.33.
All right, let's move on to Part 2, controlling the courtroom. And honestly, this is where you're going to see one of the biggest philosophical divides between the federal court and the UCPR. It's all about active case management. Look, if you only memorize one rule from this entire division, please make it this one. It's Federal Court Rule 30.23. Seriously, I call it the power rule for a reason. It gives the court this explicit list, a menu of options, to limit and control the trial. It has no direct parallel in the UCPR, and trust me, it changes everything about how you need to prep your case. So what can the court do under 30.23? Well, a judge can limit how long you have to cross-examine a witness. They can limit the total number of witnesses you're allowed to call. They can cap the length of your oral submissions. They can even limit the number of documents you can tender. They can demand written submissions and even tell you how many pages you get. This isn't passive umpiring. This is active, muscular case management right there in black and white.
And that's the critical difference right there. The UCPR's whole philosophy of justice and expediency, under Rule 5, that's a broad general power. It's discretionary. But Federal Court Rule 30.23, that's a specific, prescriptive list of tools. So what does that mean for you? It means you can never, ever walk into a federal trial assuming you have unlimited time or resources. You have to be ready for a judge to run a very, very tight ship.
Okay, on to our final section. Part 3, handling federal evidence. And just like with courtroom control, there are some uniquely federal processes here that are absolutely essential for you to know for the exam.
Let's actually kick this off with something that's pretty similar, which is always nice. If you want to use evidence from a completely different case, well, in both jurisdictions, you've got to get the court's permission. Federal Court Rule 30.25 and UCPR Rule 39.5, they're basically on the same page here. Nice and straightforward.
And we're on similar ground again with this next one. When it comes to things like plans, photos, models, physical evidence, Both Federal Court Rule 3026 and UCPR Rule 39.3 have a really common sense rule. You have to give the other side at least 7 days' notice to come and inspect it. It's all about efficiency, right? Trying to avoid the hassle of formal proof if you can just get everyone to agree on it beforehand.
Okay, now for a rule you will use all the time in practice, the notice to produce. Sure, UCPR Rule 27 covers this, but Federal Court Rule 30.28 adds a really important layer. Check this out. If you serve that notice using Form 61 and you do it at least 5 days before the trial, Subrules 3 kicks in and makes production of that document mandatory. That's right, no subpoena needed. So FCR 30.28. That's a seriously powerful and efficient tool for getting what you need.
And here we go. This is a massive difference, and it's all driven by the Commonwealth Evidence Act. The federal system has this whole formal procedure, a series of prescribed forms for giving notice about certain types of evidence. We're talking about Rules 30.29 all the way through to 30.32. These lay out the specific forms you must use for hearsay, tendency, and coincidence evidence. The UCPR has absolutely nothing like this formal notice system. This is pure, undiluted federal procedure.
Whew, okay. We've gone through a lot of rules there, so let's take a breath and boil this all down to the key takeaways, the absolute must-knows that you need to have locked away for your exam.
When you look at it, there are at least 7 key rules in this division that just don't have a direct counterpart in the UCVPR. But let's zero in on the ones you absolutely cannot afford to forget.
Okay, here are your 3 non-negotiable, must-know differences. First, the trial limitations under that power rule FCR 30.23. You have to know that one. Second, the entire formal system for federal evidence notices, that's FCR 30.29 through 32. And third, that special, dedicated rule for getting parties in custody to court, FCR 30.33. If you can master those 3 areas, you have truly mastered the core differences we're talking about today.
And when you step back, there's a simple reason for all of this. These rules aren't just different for the sake of being different, they're tailored. The federal court rules are specifically built for the unique demands of federal jurisdiction, things like the Commonwealth Evidence Act. Meanwhile, the UCPR is designed for Queensland's state courts. It's as simple as that. Different jurisdictions need different rules.
So I want to leave you with a question to chew on, because this isn't really about just memorizing a bunch of rule numbers, is it? It's about learning to think like a barrister. So knowing that a judge can literally cap your number of witnesses under Rule 30.23, or knowing you can force the production of a document without a subpoena thanks to Rule 30.28, how does that fundamentally change your strategy? How does it change the way you prepare for and run a federal trial? Because thinking through that, well, that's where the real learning begins. All the best with your studies.